Counsel,
Thank you, Counsel. What happens if a dispute arises with respect to whether or not the doctor was within the confines of Idaho law or wasn't? Is the doctor subjected to a review by a medical authority? Exactly how is that evaluated? Because it's an obvious concern if you have an individual exception for a doctor, and we're having a debate about is that covered by your submission that nothing in Idaho law prohibits complying with EMTALA. I mean, who makes the decision of whether or not something's within or without?
So, I mean, I imagine there are two ways the law can be enforced, or at least two. The Board of Medicine has a licensing oversight over a doctor, and the Idaho Supreme Court made clear that that doctor's medical judgment is not going to be judged based on an objective standard, what a reasonable doctor would do. That's not the standard. The second way would be if
what is the standard?
The doctor's good faith medical judgment, which is subjective.
And that's not subject to review by any medical board? If there's a complaint against the doctor that his standards don't comply, let's say he's the only doctor at the particular emergency room, and he has his own particular standard?
What the Idaho Supreme Court has said is that you may consider another doctor's opinion only on the question of was it a pretextual medical judgment, not a good faith one.
Thank you. Justice Thomas? Justice Alito?
Well, I would think that the concept of good faith medical judgment must take into account some objective standards, but it would leave a certain amount of leeway for an individual doctor. That was how I interpreted what the state Supreme Court said. Now, you have been presented here today with very quick summaries of cases and asked to provide a snap judgment about what would be appropriate in those particular cases. And honestly, I think you've hardly been given an opportunity to answer some of the hypotheticals, but would you agree with me that if a medical doctor who is an expert in this field were asked, bang, 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 what would you do in these particular circumstances, which I am now going to enumerate, the doctor would say, wait, this is not how I practice medicine. I need to know a lot more about the individual case. Would you agree with that?
Absolutely. And ACOG has, in the case of prom, for example, ACOG doesn't just knee-jerk say an abortion is the standard of care. ACOG itself says that expectant management is oftentimes the appropriate standard of care. And so these are difficult questions that turn on the facts that are on the ground between the doctor as he is assessing them with his medical judgment that he's bringing to bear, but is also necessarily constrained by Idaho law. Just like every other area of the practice of medicine, state law confines doctor judgment in some ways.